I think I will try to speak of all these concepts as clearly as possible, and maybe we can discuss together later on after lecture some philosophical aspects of this field, because actually international humanitarian law and environment as a topic is closely related to the developments in the philosophical field, and only after that the concern for environment became a subject of legal regulation. Yeah, and what I would like to say is that today we will discuss rather issues pertaining to the international humanitarian law as such, and during the next lecture on Monday, we will discuss them closely in connection with the context of war in Ukraine, Russian war of aggression against Ukraine, and also think of the possibilities for responsibility and accountability. But today we'll focus on what norms are there, how they govern protection of the environment during the international armed conflict. But first of all, why the terminology international armed conflict is used here in the topic of today's lecture, because from the legal side, from the viewpoint of international law, there is no war, there is no definition of war, and war doesn't exist as a legal term in general, because actually after the Second World War, there is almost no place for war in international law. So when we speak about reasons for the beginning of the war, they no longer exist. So this branch of law is called jus ad bellum, and currently there is no valid reason why to start a war. There is only possibility of self-defense, as you know, under the UN Charter and under the customary rules of international law. But today we will talk more not about the jus ad bellum, but about jus in bello, or the international humanitarian law, which, as you know, primarily has the purpose to prevent unnecessary suffering. And for the long time, these norms developed to alleviate suffering of civilian population, to protect civilians from attack, to protect civilian objects. And in all basic sources of modern international humanitarian law, you will not find a word environment, and you will not find norms directly protecting the environment. But for the additional protocol to Geneva Conventions of 1977. And this is related to the development of philosophical attitude towards environment, towards justifications of protecting environment as such, in contrast with protecting environment only then when it concerns also human well-being. But we will look at this a bit later in more detail. What drives evolution of legal norms in this direction at the intersection of the law of war, the international humanitarian law, and environment is the better understanding of how environmental systems function as such. Maybe you heard about ecosystem services, for instance, or in general the concept of how everything is interrelated in environment, so that affecting one factor also leads to the consequences for other areas. But also the second reason of development of these legal norms is the technology that enables vast environmental destruction that has been rapidly created during the second half of the 20th century, and also the development of environmental protection ethic itself. And then going back to the terminology of international armed conflict, which pertains to this domain of international humanitarian law. Why this is important? Because since 2014, the situation in Ukraine is officially could be called, from the viewpoint of international humanitarian law, as the international armed conflict. And this is supported by the reports of the International Criminal Court, where it says that since this beginning of occupation of Crimea by Russia, this is an international armed conflict. But of course, we know that the hostilities intensified in 2022, and the war became fully fledged since that time. And since that time, the scope of environmental destruction is much higher than it used to be since 2014. But when we talk about legal characterization of all of this situation together, we shall take into account all the negative consequences, all the damage caused to environment since 2014, and ideally held Russia accountable for all these violations in future. Now turning exactly to the topic of today, I'd like to pay attention also to the terminology and pose a question: what in general is environment for the purposes of the international humanitarian law? And it's actually hard to define environment as such in general, and consequently there is indeed a lack of commonly agreed definition of this term, but scientists acknowledge that it should not pose a serious problem, because environment may be broadly defined to include soil, land, water, air, living and non-living elements and physical processes altogether. And all this broad interaction of these factors is something that has to be protected during the armed conflict. Traditionally, in addition to this new development where environment as such is being protected, some objects that are essential to human survival, such as drinking water or crops, have been protected. And also some extractive resources like coal and a land that is part of urban fabric. The recent development in this field is also to try to afford special protection to the protected areas within the World Heritage Sites, wildlife, and ecosystem services. Basically, states are encouraged to conclude special agreements which will help to protect especially precious territories, like biodiversity hotspots, for instance. And also, interestingly, the International Court of Justice, the primary judicial institution of the United Nations with the seat in The Hague, as you all may know, gave eloquent description of environment in its 1996 Legality of the Threat or Use of Nuclear Weapons Advisory Opinion, where it said that the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. So as we may see, all this understanding to include a broad range of factors into environment and also to include this famous concern for future generations goes well beyond the early understanding of environmental protection within the international humanitarian law, which was concerned mainly with something like crops or drinking water. The next important question pertaining to this topic is legal categorization. Probably you also know that international humanitarian law basically divides all categories of objects and some territories into civilian objects or military objectives. And civilian objects then are afforded protection, while military objectives could be actually targeted. Unfortunately, it's like, even though the war is not kind of allowed and the war is not even there in the legal norms, there is only international armed conflict. These norms still exist to help to reduce the suffering, to make suffering less during the hostilities. And when it comes to environment, because initial sources did not include anything that was directly related to the environment, it could be called the so-called gray area, even though most of scientists agree that by default, environment shall be considered a civilian object. However, in some instances, environment may be converted to military objective. And at the same time, some environmental damage is prohibited even if the environment becomes a military objective. This refers to the so-called standard of damage, about which we will talk a bit later. And maybe you can think of examples when environment may be turned into military objectives. If someone would like to provide an example, feel free to. If not, I will continue talking that in principle, elements of environment may become military objectives when they, by their nature, location, purpose, or use, make an effective contribution to military action. And when their total or partial destruction, capture, or neutralization, in the circumstances ruling at the time, offers a definite military advantage. So hypothetically, if you imagine a forest, to illustrate these rules, the forest could be considered a civilian object as such, but it also can be a military objective once, for instance, it is used by military personnel. But then at the same time, forest may be also an object indispensable for human survival, when people depend on these forests for their sustenance. So that's why we see that sometimes environment can fall under different categories, and this clear line between legal categorization, this division into civil objects and military objective, can be a bit blurred, and it has to be decided on the case-by-case basis. But generally, environment has to be presumed to be civilian. And also, when it is considered to be as objects indispensable for the survival of civilian population, then like the full list provided in the Article 54 of the Additional Protocol 1 to the Geneva Conventions. These are foodstuffs, agricultural areas for the production of foodstuffs, crops, livestock, drinking water installations, and supplies and irrigation works. Then the next question, after talking about legal categorization of the environment as such, is categorization of damage to the environment. Whether any damage is prohibited or whether some degree of damage to a certain threshold is still allowed. Under customary international law, anticipated environmental damage must be proportional to the expected military advantage. At some very high level, environmental damage could never be justified. An explanation of this rule is that such severe damage will be disproportionate to any possible military advantage, and it will have indiscriminate effect on combatants and non-combatants. Under customary international law, the principle of distinction, necessity, and proportionality apply to the environment. And we will talk in more detail about these three leading principles of international humanitarian law, which were not supposed to regulate environment directly, but they are the broad rules which can be applied to environment as the subsequent development of subsequent interpretation of the development of the norms. And talking about, but in general, maybe the question was, you've heard of these three principles, the distinction, necessity, and proportionality. If someone heard of them, you may really raise your hand and speak.
Okay, maybe proportionality. I would say that when making an attack or attacking, it means that you measure the kind of damage that you may cause to the other side.
Mm-hmm. Okay. Yeah. Any other thoughts? Arseny, would you like to add something?
Maybe just to add.
Okay, we have Augustine.
Yeah, no, he can go first. I'll go next.
Yeah, I want to ask you to repeat all three, because proportionality and
necessity and distinction. Necessity, and proportionality.
Okay. No, I understand it even, in fact, in Ukrainian better than in English, because it's always you have legal terms, not the same as in your okay. It's like it's not so easy to say.
Just say it in Ukraine. They will translate for us.
If you like, you can say in Ukrainian.
With necessity is even much more easy, because if you have legal norm, you always just need to. But in international law, it's not so easy, because always when you in national law, it's much more easier when you like take something, you can use a kind of a sanction, and you have a special legal body to, for example, a court to do that. But in international law, the main problem is you cannot, or you cannot always, because, for example, we have Russia, and what to do? Just to say do this, they refuse. So, and what to do? We don't know exactly, because if it is so, for example, we have even a court or the highest level, but we don't have like broad effect with it, and this is the main problem maybe in this case.
Okay, and then Augustine or Augustine.
It's okay. So I just wanted to add something to complement what Stephen said on proportionality. I also understand it in terms of the weaponry, the military equipment that is used. If, for example, in Africa, we have something we call the bow and arrow, or maybe let me use a spear. I don't know if in Ukraine there are spears. If the person I'm fighting with has a spear, to bring a grenade, because a spear or spears can only kill maybe human people. But then a grenade will kill people, destroy the environment, destroy the biodiversity, contaminate the soil, contaminate the water, and all that. So that's another aspect. I understand proportionality.
Okay, it can be to some extent, yeah. And George?
Okay, for me, I feel necessity when, for example, when you are attacked, it is necessary for you to defend yourself, just like what Ukraine have done in the Russian-Ukrainian war. And also, I think proportionality, if they are using aeroplanes to attack us, also we are going to respond with the same impact or the same force, like use the same aeroplanes they are attacking us. If they are using hand grenades or all these kind of war materials, we are going also to respond the same to them and have the same impacts.
Okay, thank you. So that the same thought about the proportionality of the weapons being used. But now we will talk a bit about this proportionality as principle as such, but also Arseny would like to add something.
I want just to say about the distinction principle, but you've said, in fact, about that that we need to like distinct civilians, like they're protected entities, and so-called and combatants for sure. But we, in fact, in this law, in this part of law, we have a problem. For example, in Yugoslavian wars, or in many of African wars, like in Congo and Pan-African wars, when we have so-called paramilitary like groups, and they take into hands some some weapons and what to do with them, because there were civilians, but next not, and it's always could be a problem. Not in this conflict for sure, but it could be a problem for law, for legal limits and so.
Yeah, okay, there are rules to this extent also. When people take in weapons massively also become equated to the combatants, but this is a different set of rules. Today we will talk a bit more still about the environment, and now about all these principles. That's indeed so. As I mentioned at the beginning, this distinction between civilian objects and military objectives, this is actually the key essence of the principle of distinction, or the principle of discrimination in attacks. So when the environment is a civilian object under the principle of distinction, it may not be targeted unless it is military necessary. And the obligation to discriminate between civilian and military objects applies to all the parties of the conflict. And the principle that military and civilian personnel and objects must be distinguished is well accepted as customary international law. But by the way, do you know what customary international law is? It's just maybe the introductory lesson, introductory lecture to all these concepts. And as you know, probably there are treaty provisions which may take forms of different conventions, covenants, memoranda, and all other kinds of written international law. But there is also the so-called concept of customary international law, when we talk about the practice, state practice accepted as law by countries. And customary international law is often not codified. This is basically something that states practice and states believe that this norm exists. And that's one of the key sources of international law, along with treaty provisions. They are particularly important in international humanitarian law, which in itself is a pretty well-established area of international law, and where in 2025, the International Committee for Red Cross codified some customary rules of international law, and they issued customary rules, but written as written provisions for the ease of their use. And all these principles, the distinction, necessity, and proportionality, also pertain to customary rule of international law, but also they are reflected in also in the treaty provisions. For instance, the additional protocol to the Fourth Geneva Convention states the basic states, in order to ensure respect for the protection of the civilian population and civilian objects, the parties to the conflict shall at all times distinguish between the civilian population and combatants, and between civilian objects and military objectives, and accordingly shall direct their operations only against military objectives. And then the principle of necessity relates to actually military necessity, necessity to win this particular operation that is taking place. And prohibition of environmental damage is not justified by military necessity. This requirement is within the scope of several treaties and is now considered also customary international law. An absolute prohibition on extreme environmental damage, irrespective of whether it was associated with an act that was necessary to obtain a legal military aim, is considered by some also to be a rule of customary international law. And it is within this principle forbidden to destroy the enemy's property unless such destruction is imperatively demanded by the necessities of war. The United Nations General Assembly invoked this principle to condemn as illegal environmental damage and depletion of natural resources, including the destruction of hundreds of oil well heads and the release of waste and crude oil into the sea caused by Iraq during the 1990-1991 Gulf War. The International Court of Justice also recognized that this customary international law principle applies to environment in its already mentioned nuclear weapons advisory opinion, stating that respect for the environment is one of the elements that go to assessing whether an action is in conformity with the principles of necessity and proportionality. And now moving to this third principle, proportionality. In international humanitarian law, the principle of proportionality mainly means not the proportionality of weapons being used against each other by the parties, but proportionality of harm to the military advantage, or like to the expected military advantage. And accordingly, excessive destruction is to be considered a violation of international law. So the potential harm to the environment must be considered in planning and carrying out an action, and it is lawful only if the anticipated environmental damage is not excessive in relation to the expected military advantage. This is corollary of the principle of necessity, and extensive destruction of property not justified by military necessity and carried out unlawfully is a grave breach of Geneva Conventions and are the war crimes under the Rome Statute of International Criminal Court. The International Criminal Tribunal for former Yugoslavia, for instance, said in the report on the NATO bombing campaign that in order to satisfy the requirements of proportionality, attacks against military targets which are known or can reasonably be assumed to cause grave environmental harm may need to confer a very substantial military advantage in order to be considered legitimate. So both the importance of the anticipated military advantage and the extent, severity, and duration of the environmental harm are subjective and uncertain. And this is one of the greatest weaknesses in the legal regime. And now we are approaching the essence of the norms that are there in international humanitarian law when it comes to the protection of natural environment, namely the prohibition of the widespread, long-term, and severe damage to the natural environment. So these three key words, another set of three key words, so long-term, widespread, and severe. These prohibitions are included into this written law in the Articles 35 and Article 55 of the 1977 Additional Protocol 1 to the Geneva Conventions. And for instance, this Article 35 provides basic rules. It says that in any armed conflict, the right of the parties to the conflict to choose methods and means of warfare is not unlimited. It is prohibited to employ weapons and materials or methods of warfare of a nature to cause superfluous injury or unnecessary suffering, and it is prohibited to employ methods or means of warfare which are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment. And also, the Article 55 has similar wording, but in contrast with Article 35, which is of more general nature, Article 55 directly addresses protection of the natural environment. And namely, it says, care shall be taken in warfare to protect the natural environment against widespread, long-term, and severe damage. This protection includes a prohibition of the use of methods and means of warfare which are intended or may be expected to cause such damage to the natural environment and thereby to prejudice the health or survival of the population. What is important here in this definition and in these three keywords is that they are to be considered cumulatively, and they also set a very high threshold, which basically means that only such damage that amounts to these categories of widespread, long-term, which may mean like decades long, and severe, only such type of damage is outlawed and directly prohibited. And at the same time, it is prohibited in all circumstances, regardless the military necessity. So in this case, we're not talking about the principle of military necessity and proportionality. We are just talking about the factual damage as such, which has to be widespread, long-term, and severe. And this is kind of the additional norm to those general international humanitarian law provisions. But unfortunately, this standard has been subject to criticism because it is considered to be so high that it's almost impossible to reach it with conventional weapons. But also there is a discussion whether this standard is applicable to nuclear weapons, or maybe some other kind of standard has to be created for that purpose. And because the current regulations with regard to environment are so harsh, it is considered to be not satisfactory. And maybe that's kind of a question or a task for personal reflection, or maybe for philosophical, theological debate. What kind of threshold would be just, and what kind of threshold would be necessary to protect environment in an effective way? There is also, in addition to this wording used in the additional protocol 1, widespread, long-term, and severe, there is a convention called NMODE Convention, which is the Convention on the Prohibition of Military or any other hostile use of environmental modification techniques. So the law name, which is shortened to abbreviation NMODE. And in that convention, surprisingly, also similar wording is being used, but there is the factors used there, they are to be considered not cumulatively, but separately. So under that convention, the damage had to be either widespread or long-term or severe, and then the provisions of that convention could be invoked. And also, in addition, when we talk about environmental treaty, about treaties that protect environment during the international armed conflict, it is worth mentioning that international environmental law treaties, such as norms on protection of biodiversity under the Convention on Biological Diversity, or maybe norms on ozone depletion or climate change. So all these norms, in principle, are not cancelled by the situation of war. All these norms continue to apply, and these environmental norms are still valid. Talking further about treaty provisions, as I mentioned before, not only environment as such in this pure combination of environment unrelated to human activities is being protected, but more traditionally, the objects indispensable for to the survival of civilian population have been identified and protected. And for instance, they are worded in Article 54 of the additional protocol, saying that starvation of civilians as method of warfare is prohibited. And it's prohibited to attack, destroy, remove, or render useless objects indispensable to the survival of civilian population, such as, once again, the list: foodstuffs, agricultural areas for the production of them, crops, livestock, drinking water installations and supplies, and irrigations work. And it is also prohibited for the specific purposes of denying, to attack these objects for the purposes of denying to civilians the possibility to provide for sustenance. But additionally, there is also a prohibition on the destruction of dangerous of installations containing dangerous forces, namely dams, dikes, and nuclear electrical generating stations, which shall not be made object of an attack, even where these objects are military objectives, if such attack may cause the release of dangerous forces and consequent severe losses among the civilian population. Other military objectives located at or in the vicinity of these works or installations shall not be made the object of attack, if such attack may cause the release of dangerous forces from the works or installations and consequent severe losses among the civilian population. We all might have heard of the Kachovka Dam, which was blown last summer. And in the next lecture, we will look in more details about on the case of Kachovka Dam destruction and its legal categorization, and also possible responsibility for this act. But so at the first reading, it seems like this article about the release of dangerous forces is something that was exactly violated, almost literally what is written here, like the release of dangerous forces, such as dams. So that was about the treaty provisions. Just maybe a short summary to keep it all fresh. Traditional sources of international law, international humanitarian law, do not contain norms on environmental protection, but additional protocol of 1977 has some norms in this direction. Some of them are more broadly concentrated with objects indispensable for the survival or release of dangerous forces, but there is also a norm about protection of environment as such. However, this norm sets a very high threshold, which is almost hard to reach, because it's even not realistic to be able to make this prognose whether the consequences of some activities will last for decades. So it's only possible to characterize and identify it in retrospect sometimes. And also the next source of treaty provisions was this ENMOD convention, which has a bit lower standard, but which was not widely ratified by the states around the world. So it's maybe of lesser relevance, even though Ukraine is a party to that convention. And then we will now turn also to further customary rules identified by the International Committee of the Red Cross with respect to the environment. And these customary rules, they basically partly overlap with the conventional norms. And this is sometimes so because the fact that certain provision has been ratified by many states may also identify that it is widely accepted as a legal norm, and that's why this is also a customary rule of international law. And these customary rules of 2025, identified by International Committee of the Red Cross, have 3 articles or 3 rules dedicated to the protection of natural environment. First of them is Rule 43, which provides us with the general principles on the conduct of hostilities, and say that the following general principles of the conduct of hostilities apply to the natural environment. First, as we already, I believe, learned today, no part of the natural environment may be attacked unless it is a military objective. Second, destruction of any part of the natural environment is prohibited unless required by imperative military necessity. And third, launching an attack against a military objective, which may be expected to cause incidental damage to the environment, which would be excessive in relation to the concrete and direct military advantage anticipated, is prohibited. So here we have beautifully or eloquently written application of these 3 principles of distinction, necessity, and proportionality in the connection to the environment. And the next rule is Rule 44, which reads as due regard for the natural environment in military operations. This principle namely provides that methods and means of warfare must be employed with due regard to the protection and preservation of the natural environment. In the conduct of military operations, all feasible precautions must be taken to avoid and in any event to minimize incidental damage to the environment. At the same time, lack of scientific certainty as to the effects of the environment of certain military operations does not absolve a party to the conflict from taking such precautions. So this is closely related to the general principle or precautionary rule under international law, which says that lack of scientific certainty shall not justify inaction. So if we are not sure whether certain actions will lead to environmental damage, it's better not to take this action if we are not sure as to the opposite. And then the rule 45, the next customary rule, is about causing serious damage to the natural environment. This rule says that the use of methods or means of warfare that are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment is prohibited, and also that the destruction of the natural environment may not be used as a weapon. Basically, this principle is also in close dialogue with those articles 35 and 55 of the additional protocol to the Geneva Conventions. Now maybe talking a bit also, or extending these norms to the national context. In Ukrainian criminal code, we also have a couple of provisions that refer to the violations of rules and customs of law. And also we have a norm on ecocide. And ecocide is defined in Ukrainian criminal code as mass destruction of the flora and fauna and poisoning of the atmosphere or water resources, as well as other acts capable of causing an ecological catastrophe, which is kind of rather vague norm. And also the norm about war crimes in Ukraine is also like, the problem with those norms is that they are not precise at all. And that's why it's hard to use them in practice. And there has been some suggestions, some legislative drafts to amend these norms, but as of now, they continue to exist in this way. And that's why, on the one hand, they do provide possibility for the accountability in future, but on the other hand, they kind of lack precision. Yeah, and also interestingly, in international level, we know that as of now, there is unfortunately no crime of ecocide, but on the other hand, it's not completely problematic in the context of international humanitarian law, because in the international humanitarian law context, the particular norms that protect the environment applies, and the crime of ecocide that was suggested to be included into the Rome Statute of International Criminal Court, but was not included, is rather about environmental damage as such, both at the peaceful times and the times of war. Interestingly, also because of already identified, mentioned problems, that the threshold of environmental damage set in the traditional sources of international humanitarian law is very high. There have been some attempts to come up with different suggestions, or also the attempts to codify exactly the norms at the intersection of the environmental protection and armed conflicts. And these attempts have been made and successfully finalized in the form of draft principles on protection of the environment in relation to armed conflicts, which was prepared by the International Law Commission, ILC, the United Nations, one organization within the United Nations, which deals with the codification and progressive development of international law. So these draft principles, which were actually adopted and recommended to the states by General Assembly resolution of 2022, they continue some kind of codification and progressive development in this sphere, And we will take a look at a couple of the principles contained in this document. For instance, Principle 13, which reads as general protection of the environment during armed conflicts. This will also be perhaps the summary of what we've heard about treaty provisions and customary norms, but just formulated differently or maybe more eloquently. So the Principle 13 says of this draft principles of 2022, quite recent document, says the environment shall be respected and protected in accordance with applicable international law, and in particular, the law of armed conflict. And subject to applicable international law, care shall be taken to protect the environment against widespread, long-term, and severe damage. The use of methods and means of warfare that are intended or may be expected to cause widespread, long-term, and severe damage to the environment is prohibited. No part of the environment may be attacked unless it has become a military objective. There is also Principle 13, Principle 14 about application of the law of armed conflict to the environment, which reads as follows: the law of armed conflict, including the principles and rules of distinction, proportionality, and precautions, shall be applied to the environment with a view to its protection. Interestingly, this source suggests special protection to the protected areas, to protected zones from the ecological perspective. And it says that an area of environmental importance, including where that area is of cultural importance, designated by agreement as a protected zone, shall be protected against any attack, except insofar as it contains a military objective. Such protected zone shall benefit from any additional agreed protections. And this provision, in a way, is a bit revolutionary because it also follows the logic of kind of biodiversity hotspots or areas of special interests, and affords special protection to them on top of what is the protection afforded generally to the environment. And also, quite interestingly, maybe you might have heard about the so-called Martens Clause, the 19th century idea about, and actually coined paradoxically by someone coming from Russia, so the Frederick Martens. And it says that in cases not covered by international agreements, the environment remains under the protection and authority of the principles of international law derived from the established custom, from the principles of humanity, and from the dictates of public conscience. So here we see this application of environmental protection, but also like this general Martens Clause, which says that if we do not have any norms in this field or in this particular field, we have to follow the dictates of public conscience and the principles of humanity. And these two categories are indeed really broad and undefined. And I believe that exactly people with theological or philosophical education are to interpret these rules to kind of continue building international law based on that, or interpret particular situations in light of these broad principles of dictates of public conscience or the principles of humanity. And then, interestingly, and rightly so, international humanitarian law is important not only during the active time of hostilities, but also during the time after the kind of hot phase of the conflict is over. And this is so-called jus post bellum. So the law regulating situation after the military conflict. And this source, these draft principles of 2022, created by the International Law Commission, which is draft principles not being identified as a treaty, but potentially containing some codification of customary rules and potentially being able to become treaty one day, also have set of principles applicable after armed conflict in relation to the environment. For instance, the principle 22, peace processes, it says that parties to an armed conflict should, as part of the peace process, included where appropriate in peace agreements, address matters relating to the restoration and protection of the environment damaged as a result of the conflict. So potentially, if there will be any agreement at the end of this Russian war of aggression against Ukraine, Ukraine has to take care to include some norms about restoration and protection of natural environment also in this document, if it will be in existence one day. It also says, the next principle 24 says that relevant actors, including states and international organizations, should cooperate with respect to post-armed conflict environmental assessments and remedial measures. Principle 25 on relief and assistance says that when in relation to an armed conflict, the source of environmental damage is undefined or reparation is unavailable, states and relevant international organizations should take appropriate measures so that the damage does not remain unrepaired or uncompensated. It may consider establishing special compensation funds or provide other forms of relief or assistance. And principle 26 about the remnants of war says that parties to an armed conflict shall seek as soon as possible to remove or render harmless, toxic or other hazardous remnants of war under their jurisdiction or control that are causing or risk causing damage to the environment. Such measures shall be taken subject to the applicable rules of international law. The parties shall also endeavor to reach agreement among themselves and, where appropriate, with other states and with international organizations on technical and material assistance, including in appropriate circumstances the understanding of joint operations to remove or render harmless such toxic or other hazardous remnants of war. So we see that this set of principles on applicable after armed conflict also suggests that due care has to be taken about environment and all the damage that have been caused. However, one can imagine that it's not that easy to achieve this in practice, and not all environmental damage can also be rectified, because if we destroy fragile ecosystem with some rare endangered species by, I don't know, shelling or bombing, then it's hard to imagine by what actions the situation can be restored to the extent as if nothing happened to that ecosystem. And we know that, unfortunately, during all these attacks that already occurred by Russia in Ukraine, especially in the eastern part of our country, some protected areas have been also subject to the attacks, or in general, vast areas of lands have been attacked. So like the fertile soil was destroyed massively. Also, numerous water reservoirs were damaged, not only Kakhovka Dam. So the scope of all the damage that has been caused is massive. There is, of course, a question about whether these could be characterized as achieving this threshold of widespread, long-term, and severe. But this will be perhaps established in future. So for now, it's hard to say. But for now, one of the key tasks is just to document and collect all the materials about this damage caused to the natural environment. And with this, I would like to ask you whether you have questions and whether you would like to contribute to discussion, or maybe we can creatively think on the standard which will be appropriate instead of these three words that I repeated today many times of widespread, long-term, and severe damage. I'm keen on listening to your suggestions. Who would like to start? Evangelos Tiani.
Thank you very much for speaking to us about the many laws and ways that we could bring ecocide and environmental harm into our laws internationally, so that they can go to the ICC as crimes against humanity. And you have showed us that it is possible. Now, my worry is this: nature abhors a vacuum. And when you have a lacuna in law, you as a lawyer know that then even if you plead your case, by the end of the day, when you don't have something substantive, then there is always a challenge. So how can we push forward this ecocide law? And secondly, standings of litigants when it comes to environmental matters is always a challenge, because sometimes the idea is to prove that you are harmed directly when you go to court, and that becomes a problem, especially when I am in Kenya and I am at the ICC accusing Russia on ecocides in Ukraine, for example. Although when you harm the environment in one place, you definitely harm the environment in any other place globally. That's the reality. But then by law, I have to prove that I am directly affected. How does that go? Thank you.
Thank you. Yeah, these points are really, really important. The first one, how can we push forward the ecocide? That's not really easy. To me personally, it's still unclear why it was not accepted as one of the international crimes at the time when the Rome Statute of International Criminal Court have been drafted. It might have been much easier just to add it back then among the list, among this, so it would have been then the fifth key crime under the Rome Statute. Now it's hard. Maybe the separate conference might add this, but there is also there is a need then of political will of all member states to the Rome Statute. So it's kind of a challenging process, and there are no shortcuts to it. Or maybe a separate treaty on ecocide might be adopted, but that's also kind of not in the nearest perspective. And then the standing as a challenge, exactly, that's a huge challenge, both jurisdiction and admissibility of the cases in the international tribunals or courts, because normally for the court to have jurisdiction, then both parties have to agree to it, and also to demonstrate standing. Usually the party has to demonstrate that it's an injured party, so it has to be affected directly. There is, however, this concept of erga omnes or erga omnes partes standing, which means something that affects all. And that, for instance, have been used in front of the ICJ in some recent cases. For instance, the Gambia versus Myanmar case dealing with genocide, where the Gambia invoked the Convention on Genocide as its basis for standing, even though it's located far away from Myanmar and it is not directly affected by itself by this action. Or currently the case of South Africa versus Israel pending in front of the ICJ, which also relies on this erga omnes partes or erga omnes standing. And maybe one day something like that would be also possible in relations between Russia and Ukraine, but as far as I know, the international norms in force, so international conventions in the environmental domain ratified by both Russia and Ukraine, they do not really convey the jurisdiction of the court, because there are some also other mechanisms that have to be used or exhausted before that. So that's problematic whether it will be possible to litigate such cases in front of the ICJ. yeah, I'm not sure whether I answered your question in its fullness, but I'll give the floor now to the next participant, and maybe you can just add some remarks later. So